Thank you very much, Alex. It's a real pleasure to be here to see so many familiar faces. And there's so many topics to talk about that it's kind of difficult to restrain myself. But I want to say something about Elena Kagan to start with. Back in the 1980s, she was clerking for Justice Marshall. A case came before the Supreme Court, petition for certiorari, named Sandage versus District of Columbia. And Elena wrote a very brief analysis of the case. This gentleman had been convicted of carrying a handgun, of possessing an unregistered firearm in the District of Columbia. And he asserts his, and she put in quote marks, right to keep and bear arms. Like that's something that, is fake or whatever. And then it just says, I am not sympathetic. That was her first known commentary on the Second Amendment and the lack of importance thereof. There's a couple of people I want to just introduce you to if you haven't met them already, actually. When Sandage was going up, I assisted the defendant's lawyer, and Dan Peterson, an old friend, wrote an amicus brief. And Dan, would you stand up? People can see who you are. This was back in the 80s, and neither the brief that I helped with nor Dan's brief could convince Ms. Kagan that certiorari should be granted, or any of the other justices for that matter, apparently. But it raises an issue that really is being dealt with in D.C. right now. We have a case called Heller. We call it maybe Heller 2 to distinguish it from the first one, versus District of Columbia, and we are contesting the registration system. After Dick won his case in the Supreme Court, the district's attitude was, we're really going to stick it to gun owners now. We're going to make it harder than ever for people to own guns. And so they required not only that you register, but they mandated that your registration expires after 3 years, and you have to re-register, or if you don't re-register, you're a criminal and they take your gun. So Dick, would you stand up? Most of you probably have met Dick, but thank you for coming out tonight. Just a couple of other things about our latest Supreme Court nominee. When Prince versus U.S. was being considered by the court, that was a case that I argued, and that had to do with the Brady Act mandate on the states that local law enforcement had to do background checks instead of the federal agency doing that. It was basically a 10th Amendment case. And it was anticipated, especially after the oral argument went poorly for the government, that they would lose. And so there's a memorandum which you can see in the Clinton archives now that is posted as a result of this nomination, where it's discussing different options. And there's a comment by another person that says that Elena suggests that we explore the president making it illegal for a federal firearms licensee to transfer a handgun to a person without a background check. Now, remembering that the issue was whether background checks being mandated on states and localities was a valid exercise of constitutional power, the suggestion was made that if the court rules against that and invalidates the mandate, as indeed it did, the suggestion from Ms. Kagan was the president by decree could make it illegal for a federal firearms licensee to transfer a handgun without a background check of the type that the Supreme Court just said was invalid. So just aside from the Second Amendment, can you imagine the idea of a president making something a crime? Like, I thought Congress passes those laws. And I mean, think about that. This only, I think it was in the Post a couple of days ago it first became public, and I saw it going through those archives, and it just hit my head like a bolt of lightning that she would suggest that it could be made illegal to do something when Congress has not passed a law saying that, and the Supreme Court was anticipated to invalidate requiring local law enforcement to do background checks. And then the third thing that I think is relevant to our topic that she worked on very hard in favor of the Clinton firearm import ban actually it started in 97 and was complete in 98. Back under Bush 1, there was an import ban on firearms that were considered sporting, and the decision by ATF was that these guns are no longer sporting, even though they've been sporting since 1968, and overnight they became non-sporting. And so the manufacturers and importers changed the designs to comply with what ATF said was sporting, and then suddenly it was discovered in 1997 and 98, oh, they're no longer sporting. I mean, can you imagine, you talk about health care being decided by bureaucrats because they know so much about it. Can you imagine bureaucrats deciding what's a sporting firearm? Sort of the same thing. And so Ms. Kagan wrote the memo that Bill Clinton signed banning further importation of firearms that had been considered sporting for many years. So much for that issue. Let's do two things. Let's turn the clock back to the period 1866 to 1876 to Reconstruction and the development of the 14th Amendment and the whole issue of the black codes. After the war was concluded, the southern states reenacted the slave codes, which made it illegal for African Americans to possess firearms. And one of the purposes of a couple of statutes that were passed in 1866 and then of the 14th Amendment was to do away with these black code provisions and to protect the right of all people to keep and bear arms. And that's the history, really, that's currently before the Supreme Court right now. After the Heller decision came down, Mayor Daley defiantly said that the Second Amendment does not apply in his city. And there were several lawsuits filed. McDonald was filed the same day as Heller, McDonald versus City of Chicago. The NRA filed several lawsuits, NRA versus Chicago, Oak Park, Morton Grove, and a few other Chicagoland suburbs. And all of those repealed their ordinances, especially the most famous one, Morton Grove. That was the first handgun ban, really, in U.S. history by a locality other than the D.C. one. And it had been upheld going through the courts, and the courts basically said, well, Second Amendment doesn't mean anything. And they repealed it rather than litigate it. They kind of looked at the handwriting on the wall. And in fact, the Heller case, even though it was about whether the Second Amendment meant an individual right and whether a handgun ban was inconsistent with the Second Amendment, also did an analysis, a historical analysis that went through the Reconstruction period when the 14th Amendment was adopted. And so the court tipped its hand. The court began by saying that after the Civil War, there was considerable debate about the right to keep and bear arms and the ability and right of former slaves to do that. And it cited the book that you can buy here tonight. I'll be glad to autograph. Securing Civil Rights was cited under the subtitle, which used to be the main title, Freedmen, the 14th Amendment and the right to bear arms. And the court goes into a nice analysis of the intent to basically incorporate the Second Amendment into the 14th Amendment so that it would invalidate those black code provisions and make it lawful for all people to keep and bear arms and would invalidate gun bans at the local and state levels. So the two cases proceeded. We ended up with just the NRA cases were Chicago and Oak Park, and then McDonald. They were consolidated before the U.S. Court of Appeals for the Seventh Circuit, and that was the same circuit that upheld the handgun ban of Morton Grove back in the 1980s. And the court rendered a decision very quickly saying that, gee whiz, this is not a very old right. Federalism is has existed for more years than the right to keep and bear arms, which was a phenomenal thing to say because federalism basically was in the Anglo-American experience was invented by the framers of our Constitution. There are no states in England. And the right to keep and bear arms really goes back to ancient times. Wherever there's humanity, there's people they make tools. They have the opposing movement. Animals have their own weapons, their claws, their teeth. And humans are distinct in tool-making ability, and weapons of defense are some of those tools historically. So, but the Seventh Circuit Court of Appeals even suggested that the right to self-defense in your own home could be abolished, and therefore guns could be banned. It's a really, really wacky decision. The NRA litigants filed a petition for cert with the Supreme Court. The McDonald petitioners filed, and the Supreme Court ended up granting cert to the McDonald litigants and not to the NRA litigants, but the NRA litigants were still parties known by the weird name of respondents in support of petitioners. Something, you probably really love me to talk a long time about those terms because this legalese is so exciting. But the bottom line is exciting. The case was argued in March, and I want to say just a little bit about the oral argument. I don't know whether you read any accounts of it or not, but I want to talk about that a little bit and then go into more of the history of the 14th Amendment, because it is an exciting history, and I'm hopeful that the court will go into that history when it renders its decision in McDonald, most likely right at the end of this month. There are two clauses in the 14th Amendment that are relevant here. The 14th Amendment says that no state shall deprive any person of life, liberty, or property without due process of law. That applies to any person, and a person means an individual. It may mean a corporation like the NAACP, or a commercial entity. There's another clause that says that no state shall deprive any citizen of privileges and immunities of citizens of the United States. And that's a more complex set of phrases. I think we're all familiar with the concepts of life, liberty, and property, the Declaration of Independence saying that we're endowed by our Creator with life, liberty, and the pursuit of happiness, and life, liberty, and property is part of that. The word right doesn't appear in the due process clause, but it's presumed, it's one of the premises of the due process clause that you have a right to to life, liberty, and property that they cannot deprive you of without due process. Early on, the Supreme Court basically rendered the privileges or immunities clause something that that doesn't carry much water. And there again, I won't talk in detail about the privileges or immunities clause because it would be really boring to a non-lawyer audience. So the Supreme Court in the slaughterhouse cases in the 1870s basically read that part of the Constitution to be very narrow. And it wasn't until the end of the 19th century that the court started saying that Bill of Rights guarantees are protected against the states through the due process clause of the 14th Amendment. So the First Amendment, the Second Amendment being basically discovered by the court in 2008, it was sort of like the First Amendment was discovered by the court in about the 1920s and 30s, because there was very little case law on the First Amendment. But now it's become the most precious right of all, one would think, if you read the opinions. So gradually, one Bill of Rights guarantee after another has been incorporated and held to apply to the states, with a couple of important exceptions. The grand jury clause, that there has to be a grand jury to indict a person for a crime, and the clause guaranteeing the right of a jury trial in civil cases if the amount in controversy is over $20. Can you imagine that applying to the states? Every traffic ticket, you could get a jury trial, and the whole system would break down. Wouldn't that be cool? So those are two provisions that the court has said do not apply to the states. And the court has never ruled on whether the Second Amendment applies to the states, and that's what we're looking for. But there came a time when McDonald was before the court. There was a decision made by the McDonald litigants to rely on the privileges or immunities clause. The NRA litigants relied on the due process clause, which was the traditional way that the court had incorporated Bill of Rights guarantees. Now, when you argue a case there, or you see a case argued there, you'll discover very quickly that the justices are making speeches. They're not just asking questions. They're setting forth their positions, and they pretend to be asking questions. So you can really glean a lot from what a justice might say by the questions they ask. When McDonald's attorney was arguing, Justice Sotomayor, our new justice, said, well, if I rely on your theory that the privileges or immunities clause applies here and the Second Amendment's incorporated through that, then we've got to incorporate grand juries and all these other things against the states. And these are not gun issues, by the way, these other amendments that would be incorporated if there was privileges or immunities clause incorporation. Justice Ginsburg started asking, well, what are all these other unenumerated rights that don't have anything to do with firearms? So the court reacted very quickly against incorporation through the Privileges or Immunities Clause. And in fact, Justice Scalia asked counsel, what are you bucking for a position in law school? Because this is a favorite topic of academic professors about reinventing or rediscovering the Privileges or Immunities Clause. And Justice Breyer, who his questions take about 5 minutes, they really use up a lot of your oral argument time. He wanted to talk, instead of about the Constitution, about statistics and how guns kill people. And Justice Scalia said, well, this never comes up when you're talking about the Miranda warnings, does it? Like, if you didn't have to give those warnings, wouldn't there be a lot fewer people killed or whatever? Then the NRA had some argument time, and Justice Stevens, you can see where Justice Stevens is headed already. He's wanting to say that even if the court incorporates the right, and he definitely would not favor that, couldn't you just incorporate it in a watered-down way? For example, there does not have to be unanimous jury trials, even though the right to jury trial applies to states and localities. And so where he's headed with that is, yeah, the Second Amendment could apply to the states, but the states and localities can still ban all the guns they want to. And Justice Scalia came back with that. What about all these other rights that are the court's always recognizing that are not even in the Constitution, like abortion or the rights of homosexuals, and they're not watered down? Like, what's wrong with the Second Amendment? Why would it be a watered down version that would be incorporated? The lawyer who argued for the District of Columbia did not have a fun day. Jim Feldman, he's a guy I met back in the early 90s. I argued my first case against him. And he was asked questions like the following. He made statements like, well, England and Japan, they're democracies. They have fundamental rights that are recognized there. So how could we say that it's a fundamental right to keep and bear arms? And Chief Justice Roberts came back and said, well, we're talking about our system of fundamental rights, our system of ordered liberty, and not Japan's. So as you know, there's this internationalist trend in the court. Justice Kennedy made a very nice comment about the fundamental nature of the right to keep and bear arms. And the attorney for Chicago, squirmed when he was asked by Justice Alito, can all guns be banned? Could Chicago ban all guns? What are you going to say to that if you claim that the Second Amendment doesn't apply to the states and to localities? An individual right under the Second Amendment. So that's basically what we're hanging on the edge of our seats to be decided. And I'd like to say a little more, though, about the arguments that Chicago made in the case, and particularly their historical arguments. Chicago argues that it's okay to ban all guns for all people alike, and therefore there's no equal rights that are violated. They say that the 14th Amendment only protects the equal protection of people. Actually, I would say that would be the equal deprivation of rights of people. And as long as all people are treated the same way as the slaves were treated, for example, that's okay. The right to free speech could be banned as long as you ban it for everybody. They don't say that, but since they say it for the right to keep and bear arms, and they say that was the only intended purpose of the 14th Amendment. Then the fun really begins when we start seeing the members of Congress who Chicago quotes without telling the court who they really are. There were the two leading opponents of the 14th Amendment in the Senate were the two main people that Chicago relied on. One of those was Reverend E. Johnson. He was really one of the great constitutional lawyers of the 19th century. It just so happened, though, he had represented the slave owner in the Dred Scott case. Dred Scott held that, gee whiz, if you recognized African Americans as citizens, they would have a right to free speech, to hold political meetings, and to keep and bear arms wherever they went. So you can't recognize them as citizens. This is the shock argument. And so I think that Reverdy Johnson probably had a good idea what the 14th Amendment was intended to do, because it was intended to overrule that decision, for one thing. And among the rights, privileges, and immunities that the court made clear in that case, of citizens at least, was the right to keep and bear arms. But Chicago cited and quoted Reverdy Johnson without even mentioning that he opposed the 14th Amendment, and without telling the court that he's arguing against its adoption. How could you say that he's the one you go to get your understanding of the 14th Amendment? And then there was Thomas Hendricks from Indiana, and he argued against the 14th Amendment and against civil rights legislation at that time. And he explicitly said, in my state, we don't allow African Americans rights, privileges, and immunities. And one of those rights, privileges, and immunities in Indiana was the right to keep and bear arms. And Hendricks well knew that, because he was a delegate at the Constitution that adopted that provision in the state Constitution. And he's the other main person that Chicago quotes and relies on for its argument that, well, nobody really understood the 14th Amendment to protect substantive rights. It was only about equality, and as long as everybody's treated equally badly, then everything's okay. Now, one of the most important speeches, though, that Chicago disregards, or actually they try to minimize, was by Jacob Howard when he introduced the 14th Amendment to the Senate. He gave a long speech, very interesting speech, where he talks about the fact that previously the Supreme Court had said this Bill of Rights does not apply directly to the states. And he talks about the intent of the 14th Amendment to make sure that the Bill of Rights does apply to the states. And he goes on to say that there are individual rights, privileges, and immunities that are before the Congress that are at stake in the proposed 14th Amendment. And he went ahead and read those that he thought were most important. And guess what? The Second Amendment was one of those. And he calls these personal rights. Now, this is the guy who introduces the amendment to the Congress. Chicago doesn't think that's of any relevance, but he goes on to talk about the fundamental rights that exist in every society that's not a slave society or a despotism. And by talking about the right to keep and bear arms as a right, he made that discussion in terms of it being a right and not a privilege and immunity of citizens, because he said it applied to the people. And his speech has been misread by some scholars to rely on the privileges or immunities clause, but in actuality, he clearly distinguishes privileges or immunities of citizens from rights of the people. And the right to keep and bear arms was a right of the people. And when he made that comment about slave societies and despotisms, he said that, what are those rights? Now, notice he didn't say that it would be a despotism or a slave society if you don't have a right to a jury trial in a civil case where it's more than $20 at stake. And he did not cite the grand jury clause, but he did talk about free speech, assembly, keeping and bearing arms. So this speech, by the way, was published on the front page of the New York Times and reprinted in a lot of newspapers. And Chicago said, well, not many people read that, and it was a really long speech, and how would they understand all that? It was just too complicated. And it's right there in black and white. He says, he reads the provisions of the Bill of Rights that he selected as important, including the right to keep and bear arms, and he says that this amendment is intended to protect these rights from state deprivation. So as you can see, Chicago is really stretching it and really on a limb in terms of, they got some really weak arguments. It's nice to go in court even if you have kind of a bad case and you got some good arguments, but I mean, this is really unprecedented to go into court and basically on a 14th Amendment issue rely on the most racist members of the Congress at that time who opposed the amendment and to act like that's what the court should adopt as its understanding. Now, there's just an awful lot of people I could quote about the right to keep and bear arms at that time, and you got to get the book, and I won't bore you with it now, but it's not boring, but it's things like the following. You know how they always used to argue the Second Amendment only protects a militia right? Well, here you had right after the Civil War concluded under the Black Codes, the gun seizures against African Americans were carried out by local law enforcement and by militias. And the Congress responded to that by banning the southern state militias and basically trying to protect the rights of African Americans to keep and bear arms. And after it became clear that the states could not have laws banning gun possession, that's the point when the Ku Klux Klan came on the scene, and they deprived African Americans of firearms, deprived them of firearms, and basically terrorized them if they were voting Republican, and committed various outrages of that type. And you can glean for the entire period of Reconstruction, this being a central issue, if not one of the most central issue of all. I mean, the Second Amendment was the only amendment mentioned in one of the civil rights type statutes that Congress passed in 1866, where the court referred to the rights of personal security, personal liberty, and private property, including the constitutional right to bear arms. They didn't say that about free speech or any other right. Now, Chicago is getting really worried about what it's able to do. They argue for flexibility and the ability to ban guns that are evil in their view. And they actually made the argument in their brief that, well, if you say as a categorical manner that rifles, pistols, and shotguns cannot be banned because they're protected by the Second Amendment, what if Chicago needed to ban these rifles with scopes that in rural areas are used for hunting, but this becomes a favorite tool of gang members to assassinate each other, and there might come a time when Chicago needs to ban hunting rifles with scopes in an urban area, because they try to say that you can do things in urban areas that you cannot do constitutionally in rural areas. So there we have it. I'm glad they put that in their brief, because it shows you what's going on here. We're in Alice in Wonderland. Language can mean anything you want it to mean. You know, an assault weapon or an assassination tool can be whatever gun you want to assign that term to be, and therefore to justify banning it. So Chicago basically argues they can ban any gun they want to ban, and they're sticking with it. So we'll see how much they're able to stick with this after the decision comes down. I would fully expect they're going to try to make things as miserable for gun owners as possible if they do lose the case, and we'll just have to wait and see about that. But keep tuned the first couple of days of the last week in June, this month, June, and we should have a decision. So I'll stop there and turn it over to Nelson. Thank you.